Wow, actually, this sounds really, really nice. I mean, better than I expected. So anyways, we're doing lesson number 1 right now, and we are actually doing chapter 1, fundamentals of law. So this is basically fundamentals of law. So let's do it. Question 9. When commencing a lawsuit in small claims court, the plaintiff may originate the action in the jurisdiction where, the answer is 3, either the cause of action arose or the defendant resides. So you either where the shit happened or where the defendant, which is the other person, lives. That was question 9, answer 3. 14. Which of the following is not a possible meaning of the term common law? And the answer to this is 3. The laws created by the federal government in accordance with its power under the Constitution. Common law has nothing to do with the feds or the Constitution. But the other answers are true, which is the law created by the courts as opposed to statute law. The principles derived from the common law courts in England as opposed to the principles derived from the courts of chancery. And for this system of law which relies upon the principle of stare decisis for its development. So actually, remember the answer is 3, which is not possible, meaning is the laws created by the federal government in accordance with its power under the Constitution. All right, and so we have page 3 happening here. Oh, and I just want to read a little bit more about the question 14. The expression common law can have several meanings. It refers to the law created by the courts, based in either common law or equitable principles, as opposed to statute law, which refers to the body of law made by the federal or provincial legislatures. Answer 2 is another possible definition of common law, as it could refer to the original set of court-developed principles that evolved separately from equitable principles. Answer 4 refers to an important concept in the common law system, the doctrine of stare decisis, which underlies the binding nature of precedent within the common law. And then answer 3 does not describe a meaning of the term common law. So going back there, we did have an answer of 3. Question 23. An appeal from the small claims court is to 3, and let me make sure I'm correct here. Yes, it's not 3. It's to the BC Supreme Court. So an appeal from the small claims court is to, answer 23, the BC Supreme Court. You got that? It goes on from small claims court to the BC Supreme Court. And I better check that in my book. Question 38. Which of the following, and I'm going to put a question mark on there, because I don't know if that is true. So 38, which of the following falls within the category of law called public law? And the answer for 38 is 3, constitutional law. Constitutional law, public law. Public law, constitutional law. All right? Those are together. Constitutional law, public law. That's question 38. I will continue on page 4 here. Question 102. In Canada, the power to make laws is divided between the federal and provincial levels of government. Which of the following have been assigned to the federal government? Oh, I remember this one. And the answer is 2. 2 is A, B, and D only. A, B, and D. So we got A, jurisdiction over harbors, not Stephen Harper, but the harbors. You know, the bay, down by the bay, where the water lily grows. All right, and then we've got what was my answer here? Oh yeah, 102, yeah, the answer is 2. So we got A, B, and D only. A, B, and then, B is jurisdiction over the regulation of the height of buildings and structures around airports, okay? So we got the height of buildings and structures around airports. So that's true. And then we got jurisdiction over the regulation to protect fisheries. So we got harbors, A. We got airports, or buildings around airports. And then we got fisheries. So that's A, B, and D. That's answer 2. Question 148. What is the result of the doctrine of stare decisis? And the answer is 4. All of the above. And what are all of the above? 1. Former decisions are used as a basis for later decisions. 2. The common law system has uniformity. Remember that word, uniformity, for stare decisis. And 3. Decisions by the Supreme Court of Canada are accorded the most weight in our jurisprudence. Decisions by the Supreme Court of Canada are accorded the most weight in our jurisprudence. So all of the above result from the doctrine of stare decisis, and the answer is 4. And we move on to question the sheet 5, page 5. Question 164. Which of the following statements is false? And the answer for the false one is 4. An appeal by a taxpayer to reduce a tax assessment would fall within the sphere of private law. That is not correct. It's not true. Taxpayer wants to reduce their tax assessment. That's not private law, sirs. These other things are true. The doctrine of precedent provides uniformity to the common law system. To the Supreme Court of Canada is not required to hear all appeals. It's true. And 3, the Supreme Court of BC may exercise both common law and equitable jurisdiction. That's also true. But this thing is blatantly false. An appeal by a taxpayer to reduce a tax assessment would fall within the sphere of private law. No! 4 is false. And that's the right answer. Question 223. Which party to a court proceeding files a response to civil claim? And the answer is 223, the defendant. The defendant files a response to civil claim. Question 384, when a judge distinguishes a case on its fact, this means what? And the answer to that is 1. The judge decides that facts crucial to a former decision are not present in the case at hand and does not follow the former decision. Who doesn't follow the former decision? The judge. So when a judge distinguishes, distinguishing means that the judge decides that the facts crucial to a former decision that he or she is looking at, they're not present in the case that at hand, and he or she doesn't follow that former decision. That's called distinguishing, which is kind of going in a new direction, different direction. Question 489, which of the following does not fall within the body of public law? And 489, the answer is 3, agency law. Agency law doesn't fall within the body of public law. Yes, agency law does not follow within the body of public law. The other things do, like tax law, criminal law, constitutional law. They are all within public law, but not agency law, okay? 528, which of the following statements about the trial process in BC are true? And the answer is 3. Only A, B, and C are true. Okay? Only A, B, and C are true. So we got A, B, and C. So, let's see, A, B, and C. Let me just double check this. Yes. A, B, and C. A means our common law system is based on an adversarial process in which each of the two opposing parties present its point of view to an impartial trier of fact whose decision is binding on both parties. That is absolutely true. B is also true. A plaintiff commences an action by filing a notice of civil claim in the court registry. Once served with the notice of civil claim, a defendant can answer by denying some or all of the claims set out in the plaintiff's notice of civil claim by filing a response to civil claim. And that's exactly what I did. I went to the Port Coquitlam, Family Justice Court. I had filled out a notice of civil claim, and the defendant filed a response to the civil claim. And C is also true. One of the major reasons why most claims are settled out of court is that the discovery process allows the parties to see more plainly the strengths and weaknesses of their positions. Okay, so the discovery process, it kind of helps people avoid going to court and wasting a lot of taxpayer money. So the answer is 3, only A, B, and C are true. Turning to page 7, we've got question 639. There are several steps taken before a lawsuit actually is brought before a judge. Which of the following procedures does not take place before a trial begins? And the answer is 4, obtaining a garnishing order. That may happen after if there's judgment, but it doesn't happen before. But the other things do happen. Filing and serving a notice of civil claim, filing and serving a response to civil claim, and conducting an examination for discovery. That happens. All right? File and serve a notice of civil claim, file and serve a response to civil claim, and conduct an examination for discovery. Those things happen before a trial, but not garnishing. 685. Question 685. Precedents form a major part of the common law system. Another major source of our law is legislation. Which of the following could be called legislation? And the answer is 1, the Land Title Act. The Land Title Act is what we call legislation. Page 8, question 741. Where a case is brought before a judge of the BC Supreme Court, yes, the judge may exercise both equitable and common law jurisdiction in deciding the matter. So where a case is brought before a judge of the BC Supreme Court. So remember, we're talking about the BC Supreme Court here. So that judge too may exercise both equitable and common law jurisdiction. The two different kinds of law in deciding the matter, equitable and also common law. You got that? And we've got 793. Which of the following statements is true? 793, and the answer is 2. An appeal from the BC Supreme Court is to the BC Court of Appeal. So, do you remember the order there? The order goes, first it goes to Small Claims Court, which is 25 grand. I think it's below 25 grand, basically. And then if something goes wrong there, they can appeal to BC Supreme Court. And it could go on from BC Supreme Court to the BC Court of Appeal. That is true. All right, for 793. But the things which are false, okay, don't even bother with it. 805. Which of the following statements concerning the equitable jurisdiction of the court are true? And the answer is 3. Only A is true. A, which is the rules of equity developed as a remedy for the rigidity of the common law in England. So basically what happened is that in England, common law became very rigid. So what happened is there was another system that developed parallel to the common law in England, and that was called the rules of equity. Yep. So we go moving on to page 9. Page 9. Oh, and I just want to read a little bit more about this answer to 805. This question requires a distinction be made between equity, which means equitable jurisdiction and remedies, and the common law. Statement A is true, as the rules of equity were a response to rigid rules and the frequently inequitable results that occurred. Statement B is false, since the court will usually apply equitable principles when a conflict exists with the common law. However, statement C is also false, since parties to an action can't demand an equitable remedy as a right. All right, it's not a right, as equitable remedies are awarded at the court's discretion. Finally, examples of equitable remedies include specific performance and injunction, but damages are a legal remedy and are awarded solely under common law. So damages belong to common law. 812, governments pass statutes in order to, 1, change the common law. Governments pass statutes in order to, number 1, change the common law. 830, when a judge in the BC Supreme Court exercises equitable jurisdiction, 2, he or she may grant such remedies as specific performance or an injunction. When a judge in the BC Supreme Court exercises equitable jurisdiction, 2, he or she may grant such remedies as specific performance or an injunction. 897. There are several procedural steps involved in the trial process in BC. Some of these procedures are called 4. CBAD. The answer for procedural steps in the trial process is CBAD. And CBAD is C, filing and serving a notice of civil claim, B, filing and serving a response to civil claim, A, conducting discovery proceedings, and D, enforcing a judgment. I already knew that, right? 905. Which of the following statements is not true? And the answer to this is 3. In a conflict between statute law and equitable principles, equitable principles will prevail. No, not necessarily. But these other ones are true, okay? Just wait a second. Let me just reinforce here. This is not true. If you have a conflict between statute and equitable principles will prevail. No, that's not true. But the other situations are true. In a conflict between common law and equitable principles will prevail. Yes. In a conflict between common law and statute law will prevail. Yes. And in a conflict between equitable and statute law will prevail. Yes. So as far as I can see, it seems to me that the highest form of law is statute law. Right? Statute law. It goes, let me write this down. Statute. Then we got, so that's the highest. And then we got equitable principles. That's the second highest, equitable. And then we got common law. So basically, what I just said in 905, the answer 3, it's wrong that when you say statute, conflict between statute and equitable prevail? No, it is statute will prevail, which is the true one of number 4. Statute is first, equitable is second, and common law is third. You get it? We go to page 11 here, and question 919. Which of the following would not be available to a judgment creditor as a means of enforcing a judgment? And the answer is 4. Registering a notice of civil claim in the appropriate land title office against the judgment's debtor's property. You can't do that. You can't register a notice of civil claim in the land title office. First of all, land title office is not a court. And second of all, you cannot, you can touch the property, but it won't be through the land title office. But these other things are true. You can examine under oath the judgment debtor. You can obtain a writ of execution so that the judgment debtor's personal car can be seized, and you can obtain and serve a garnishing order on the judgment debtor's bank. So you can do those things. You can examine under oath the judgment debtor. You can obtain a writ of execution to take the car, seize the car, and you can obtain and serve a garnishing order on their bank account. But you cannot deal with the land title office, okay? Got that? Land title office has nothing to do with it. 936, equitable remedies are remedies which are within the court's discretion to award. Which of the following is not an equitable remedy? And the answer is 4, damages. Damages is related to common law. Do you remember that? Damages related to common law, not to equitable principles. You get it? But these other things are equitable remedies: specific performance, injunction, and quantum merit, which means, I believe, it means the labor is worthy of his wages. Something like that. So there we have SIQ, sick, man. Equitable means sick. Equitable means sick. Specific performance, injunction, and quantum merit. So maybe we say spick. No, we say sick. Sick with a Q. Not damages. Got that? Damages related to common law. 963. Which of the following is not included in the concept of real property? And the answer is 2. Not movable objects such as furniture. Those are chattel. Chattel is not real property. You get it? These other things are natural features such as trees and streams, movable object, 1, natural features such as trees and streams, 3, land, 4, man-made improvements such as buildings that are fixtures, but not movable objects. 978 on page 12, the term stare decisis means, and the answer is 2. Let the former decision stand, okay? So I think stare means stand, right? It means hold forever, and decisis means the decision. Something like that. Let the former decision stand. That's what stare decisis means. 992. A new furnace that Sally installed in her house exploded 6 months after installation. Sally intends to bring a lawsuit against the manufacturer. The first document that Sally's lawyer will file is, and I don't even need to look at the answer key, I think it's 3, a notice of civil claim. Yes, it is 3, a notice of civil claim. That's the first thing that Sally's lawyer files. And we had 12 pages here. It's all done. Chapter 1, Fundamentals of Law. Lesson 1, Fundamentals of Law and the Real Estate Services Act. Thank you very much, and we'll have Chapter 2 of Lesson 1 coming real soon on a CD near you.